Mr. Scott. For what purpose does the gentleman from Virginia rise?
Mr. Speaker, I move to suspend the rules and pass Senate Bill S. 1789.
The clerk will report the title of the bill.
Senate 1789, an act to restore fairness to federal cocaine sentencing.
Pursuant to the rule, the gentleman from Virginia, Mr. Scott, and the gentleman from Texas, Mr. Smith, will each control 20 minutes. The chair recognizes the gentleman from Virginia.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material on the bill under consideration.
Without objection.
I yield myself such time as they may consume.
The gentleman's recognized.
Mr. Speaker, S. 1789, the Fair Sentencing Act of 2010, is a bipartisan compromise that was negotiated and drafted by Democratic and Republican members of the Senate Judiciary Committee, then passed the Senate Judiciary Committee and the Senate by unanimous consent. The legislation will reduce the 100-to-1 sentencing disparity between crack and powder cocaine in federal law from 100-to-1 down to 18-to-1. The crack penalties under present law, for example, it only takes 5 grams of crack to trigger a 5-year mandatory minimum sentence, but for powder cocaine it takes 500 grams to trigger the same 5-year mandatory sentence, a 100-to-1 ratio. This disparity is particularly egregious when you consider that the Sentencing Commission has concluded that there is no pharmacological difference between the two forms of cocaine and that 80% of the crack defendants are black, whereas only 30% of the powder cocaine defendants are black. The crack penalties also create bizarre sentences when you consider sentences such as a 24-and-a-half-year sentence given to Kimba Smith for behavior that was just inferentially involved with her boyfriend's cocaine dealing. The legislation moves the threshold amount for the 5-year mandatory minimum from 5 grams to 1 ounce, reducing the disparity from 100-to-1 to 18-to-1. Now, the legislation does not fully eliminate the 100-to-1 disparity in sentencing for crack and powder, but it does make good progress in addressing what is widely recognized as unfair treatment of like offenders based simply on the form of cocaine they possessed. The bill also addresses another concern. Arguments are made that crack defendants are more likely to use violence or minors in the distribution, and this bill specifically requires the Sentencing Commission to significantly increase penalties for drug violations involving violence, threats of violence, or use of minors, and another long list of aggravating activities that would be involved. This way, the defendant is sentenced for what he or she actually did, not the form of cocaine involved. Many organizations are supporting S. 1789, including the Federal Law Enforcement Officers Association, the National District Attorneys Association, National Association of Police Officers, the Council of Prisons Locals, and several conservative religious organizations such as Prison Fellowship and the National Association of Evangelicals. And all of the civil rights organizations that one can imagine are also supporting the legislation. I'd like to thank the sponsors of the Senate bill, Senators Durbin of Illinois and Sessions of Alabama, and Orrin Hatch of Utah, who came together to pass this important bipartisan legislation. And there are many members of the House who've worked tirelessly over the years to reform this disparity, including Chairman of the Judiciary Committee, Mr. Conyers, Sheila Jackson Lee, Maxine Waters, Charlie Rangel, and Mel Watt. On behalf of the organizations and members of Congress who support S. 1789, I urge my colleagues to support the legislation, and I reserve the balance of my time.
The gentleman reserves. Gentleman from Texas.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, those who fail to learn the lessons of history often pay a price. Unfortunately, the real cost usually falls on others. In the 1980s, America faced an epidemic created by a new, more potent form of cocaine known as crack. Its abuse spread through major cities and across the country at a stunning speed. Along with crack came guns and violence, which riddled many urban communities. These communities cried out for help, and in 1986, Congress responded. We enacted tough penalties to protect these neighborhoods and bring an end to the scourge of crack cocaine. And the penalties helped make America's communities safer. Now Congress is considering legislation to wind down the fight against drug addiction and drug-related violence. Reducing the penalties for crack cocaine could expose our neighborhoods to the same violence and addiction that caused Congress to act in the first place. 25 years ago, crack was cheap, easily available, and highly profitable. According to the Drug Enforcement Agency, never before had any form of cocaine been available at such low prices and at such high purity. As a result, the number of Americans addicted to cocaine increased dramatically. Crack cocaine devastated many communities, especially inner-city communities. Black Americans who lived in these communities bore the brunt of the violence associated with the drug trade. Today, crime rates, particularly for violent crimes, are at their lowest levels in more than 30 years, thanks in large part to the enactment of tough penalties for drug trafficking and other offenses. Crack and powder cocaine use has dropped by almost two-thirds in the past 20 years, from 5.8 million users in 1985 to 2.1 million users in 2007. According to the Bureau of Justice Statistics, crime victimization rates for Black Americans have fallen by more than two-thirds since enactment of these tough federal trafficking penalties. What's wrong with that? Why do we want to risk another surge of addiction and violence by reducing penalties? Many argue that federal prisons are filled with addicts convicted of simple possession of cocaine, but that's not true. The vast majority of federal drug offenders are convicted for drug trafficking. In fiscal year 2009, the U.S. Sentencing Commission reports that there were 25,000 federal drug trafficking convictions compared to fewer than 300 convictions for simple possession. So why do we want to make it more difficult to take drug traffickers off the streets and easier for them to peddle their lethal product? Crack cocaine is associated with a greater degree of violence than most other drugs. Crack offenders are also more likely to have prior convictions and lengthier criminal histories than powder cocaine offenders. It is these aggravating factors, which are more common to crack cocaine trafficking, that contribute to higher federal crack sentences. These aggravating factors also render many federal crack offenders ineligible for the so-called safety valve provision. The safety valve allows low-level offenders to be sentenced below the statutory mandatory penalties if they meet certain criteria, including no significant criminal history. So why should we reduce the ratio for defendants who are more violent, more likely to have criminal records, and less likely to benefit from the safety valve provision that already provides a mechanism for reduced penalties? Why are we coddling some of the most dangerous drug traffickers in America? Proponents of reducing or eliminating the crack-powder ratio argue that crack penalties impact a larger number of minorities than powder cocaine penalties. But the percentage of minority defendants for federal crack and powder cocaine offenses is quite similar. 82% of crack offenders and 90% of powder cocaine offenders are minorities, though Black Americans comprise the majority of federal crack cocaine offenders. Crack and powder cocaine offenders are even sentenced with mandatory penalties at similar rates. In 2009, 80% of crack cocaine offenders and 77% of powder cocaine offenders were convicted under a mandatory penalty statute. The bill before us today, S. 1789, lowers the ratio for federal crack cocaine offenses from 100 to 1 to 18 to 1. The bill also eliminates the mandatory penalties for crack cocaine possession, making it only a misdemeanor under federal law. Why enact legislation that could endanger our children and bring violence back to our inner city communities? S. 1789 includes a requirement that the U.S. Sentencing Commission review and amend the applicable guidelines for crack offenses involving violence. However, since federal judges are not required to adhere to the guidelines, there is no guarantee that any increased penalty will be imposed under this provision. Last year, the House Judiciary Committee reported legislation over Republican opposition that would have eliminated entirely the ratio between crack and powder cocaine. Before that, the Obama administration relaxed enforcement of marijuana laws. Mr. Speaker, the Democratic Party teeters on the edge of becoming the face of deficits, drugs, and job destruction. I cannot support legislation that might enable the violent and devastating crack cocaine epidemic of the past to become a clear and present danger. Mr. Speaker, for these reasons, I urge my colleagues to oppose this legislation, and I'll reserve the balance of my time.
The gentleman reserves. Gentleman from Virginia.
Mr. Speaker, I yield 3 minutes to the Majority Whip, the gentleman from South Carolina, Mr. Clyburn.
Thank you very much, Mr. Speaker. I want to first thank my good friend, Subcommittee Chairman Bobby Scott, for yielding me this time and for his leadership on this very important issue. He and Committee Chairman Conyers have worked for years to eliminate the unjust and discriminatory sentencing disparities between crack cocaine and powder cocaine. Although I'm disappointed that this measure does not entirely eliminate the disparity, I want to commend Senators Durbin and Sessions and Coburn for crafting a very significant compromise. The Fair Sentencing Act of 2009 will significantly reduce the disparity in sentencing for crack and powder cocaine and help to correct an enormous disparity in our criminal justice system. When the current law was passed, Congress felt that crack cocaine was a plague that was destroying minority communities. 20 years of experience has taught us that many of our initial beliefs were wrong. We now know that there's little or no pharmacological distinction between crack cocaine and powder cocaine. Yet, the punishment for these offenses remains radically different. Down where I come from, Mr. Speaker, we say that when one learns better, one should do better. Equally troubling is the enormous growth in the prison population, especially among minority youth. The current drug sentencing policy is the single greatest cause of the record levels of incarceration in our country. 1 in every 31 Americans is in prison or on parole or on probation, including 1 in 11 African Americans. This is unjust and runs contrary to our fundamental principles of equal protection under the law. Since 1995, the United States Sentencing Commission has issued report after report calling on Congress to address this unfair disparity. According to the Sentencing Commission, restoring sentencing parity will do more than any other policy change to close the gap in incarceration rates between African Americans and white Americans. The American drug epidemic is a serious problem, and we must address that problem. But our drug laws must be smart, fair, and rational. The legislation we consider today takes a significant step towards striking that balance, and I'll yield back the balance of my time.
Gentleman's time has expired. Gentleman from Texas.
Mr. Speaker, I'll yield 2 minutes to the gentleman from Wisconsin, Mr. Sensenbrenner, a former chairman of the Judiciary Committee.
Gentleman from Wisconsin is recognized for 2 minutes.
Speaker, I rise in support of this legislation. It is a fair compromise. It dealt with conflicting issues, and it looked at the data on who was indicted and who has been sentenced, both by race as well as by the amount of cocaine that they possessed. Unlike some allegations, this bill does not let those who possess crack cocaine off easily. The sentencing disparity is 18-1. That means that someone who possesses crack cocaine only has to have 1/18 of the amount of someone who possesses powder cocaine. So I don't think the people who either deal in crack cocaine or who possess crack cocaine are getting off the hook by reducing the ratio from 100 to 1 to 18 to 1. The Sentencing Commission has been set up by this Congress to look at sentencing patterns and to look at sentencing statistics. For the last 15 years, they have called for a change in the disparity and the minimum sentences between those who are indicted for violating the crack cocaine laws versus those who are indicted for violating the powder cocaine laws. This is a very fair compromise. I salute the three members of the other body who worked the compromise out. It is a compromise that should be endorsed by this House and sent to the President. I urge an aye vote and yield back the balance of my time.
Gentleman yields back. Gentleman from Virginia.
Mr. Speaker, I yield 2 minutes to the gentlelady from Texas who has sponsored one of the many bills on this issue and worked as hard as many people on to eliminate the disparity altogether. Ms. Sheila Jackson Lee.
Gentlelady from Texas is recognized for 2 minutes. Without objection.
I want to thank the gentleman from Virginia for being a champion of this issue of eliminating the disparities that have so long plagued so many communities. I thank the chairman, John Conyers, for being persistent over the years on the criminal justice issues, even coming to Houston, Texas, and listening to a teeming room of individuals who came to tell him how they had been discriminated against by this overwhelming inequitable law dealing with crack cocaine. Thank you. Today, we're doing something that is not going to be soft on crime. But let me see if you understand this. It takes 500 grams of powder cocaine to trigger the 5-year mandatory minimum. It just takes 5 grams of crack cocaine. Similarly, it takes 5 kilograms of powder cocaine to trigger the 10-year mandatory minimum, but 50 grams of crack cocaine. And so it is important that this 1 to 18 be put in place in response to the 1980s when we thought this devastating act of using drugs was the underpinnings of crime. But what we have seen and what the U.S. Sentencing Commission has seen is that we're creating crime by throwing these individuals in jail instead of rehabilitation and by keeping this oppressive sentencing structure. Right. So for the first time, we're eliminating the 5-year mandatory minimum prison term for first-time possession of crack cocaine, and it encourages the U.S. Sentencing Commission to amend the sentencing guidelines. In addition, however, there's more to go. Passing the Promise Bill to detour young people away from crime. H.R. 265, the bill I introduced, which was the underpinnings of the S-1789, had a number of other provisions that would be dealing with rehabilitation in drug courts. And so there's more work to be done, Mr. Speaker, but I believe this is the first step, and all real good-thinking Americans who understand justice will appreciate the fact that we are eliminating these disparities. In particular, I will say to you that this fell heavily on the poor African American and Hispanic community.
Gentlelady is recognized for an additional minute.
I thank the distinguished gentleman. So statistics are very clear that the burden fell on a population that suffered more by not getting into rehabilitation than others. It is very clear that those numbers are strong. So I would simply say to us as we begin our work on this, this is the first step. And I would say to the distinguished members that we can do better on rehabilitation, drug court intervention, which allows people to get into rehabilitation and have an obligation to finish. And the main thing that I want to leave us with, doing this will help us detour any numbers of individuals to be able to support their family and maybe be real role models for children who we likewise want to detour away from crime by having an innovative juvenile justice system by passing this bill and going on to have criminal justice reform as we pass the Promise Act as well. I yield back.
Gentlelady yields back. Gentleman from Texas.
Mr. Speaker, I yield 2 minutes to the gentleman from California, Mr. Lundgren, a senior and active member of the Judiciary Committee.
Gentleman from California is recognized for 2 minutes.
Thank you very much, Mr. Speaker. I rise in support of S-1789, but as someone who helped write the Drug Control Act of 1986 that we seek to amend, I'd like to make a few observations to set the record straight. It is indeed true that the death of basketball star Len Bias served as an exclamation point concerning the threat posed to our nation by the scourge of illegal drug use. The fact that someone who seemed bigger than life could fall prey to the growing cocaine epidemic brought home the reality of the danger to every home with a television set that had tuned into the University of Maryland basketball games. And that reality was not lost on this body. The number of Americans addicted to cocaine dramatically increased in the 1980s, thanks in major part to the escalation in crack use. Hospital emergencies increased by 110% in 1986. From 1984 to 1987, cocaine incidents increased fourfold. The crack epidemic was associated with a dramatic increase in drug gang-related violence. A 1988 study by the Bureau of Justice Statistics found that in New York City, crack use was tied to 32% of all homicides and 60% of all drug-related homicides. I would add that even 5 years after the drug bill was considered on this floor, there was a growing concern over the crack epidemic which plagued minority neighborhoods. The acclaimed depiction of this scourge was even portrayed in the movie New Jack City. Director Mario Van Peebles, also one of the main characters in the film, observed at that time that the immediate problem is that crack is and was a killer in the black community today. That's what we faced at the time we passed this bill. This is the context of the crack epidemic and the 1986 drug bill. The concern about crack cocaine was, and in my view, remains a valid one. According to the National Institute on Drug Abuse, crack causes faster and shorter highs than powder, which results in more frequent use. Crack cocaine is also associated with gang activities and violence as evidenced by the U.S. Sentencing Commission data. There is, in my view, a basis for disparate treatment of those who traffic in crack versus powder. Having said that, the conclusion that there's a basis for treating crack and powder differently is in no way a justification for the 100-to-1 sentencing ratio contained in the 1986 drug bill. We initially came out of committee with a 20-to-1 ratio. By the time we finished on the floor, it was 100-to-1. We didn't really have an evidentiary basis for that, but that's what we did, thinking we were doing the right thing at the time. Certainly one of the sad ironies in this entire episode is that a bill which was characterized by some as a response to the crack epidemic in African American communities has led to racial sentencing disparities which simply cannot be ignored in any reasoned discussion of this issue. When African Americans, low-level crack defendants represent 10 times the number of low-level white crack defendants, I don't think we can simply close our eyes.
Gentleman's recognized for an additional minute.
Although I cannot and could not support the legislation reported out of our committee to completely eliminate any disparity in the treatment of these illicit substances, that is not what we have before us today on this floor. I must say that from a law enforcement standpoint, perhaps the most important factor here is the amount of the substance that's covered. According to narcotics officers I've spoken with, you want to reach the wholesale and mid-level traffickers who often traffic in 1-ounce quantities. That's why S. 1789 would raise the amount of crack cocaine necessary to trigger a mandatory 5-year sentence from 5 grams to 28 grams, which is close to the 1 ounce. This does seem to make some sense. It is fair and just treatment of the problem. It serves the interests of law enforcement in reaching wholesale and mid-level traffickers while reducing the crack powder ratio to 18-to-1 from the current 100-to-1. I think this is tough but fair. I would not support going further. I support this bill very strongly. I believe that this is what justice should be about. This is a well-crafted bill, a good compromise. It serves the ends of justice and fairness. I hope people will support it.
Gentleman yields back. What purpose does the gentleman from Virginia rise?
Mr. Speaker, I yield myself 30 seconds to make a brief comment. The gentleman from California just mentioned the 1986 law. We're not blaming anybody for what happened in 1986, but we've had years of experience and have determined that there is no justification for the 100-to-1 ratio. We know that's what we know now, and so we're not blaming anybody for what happened in 1986, but we are fixing what we have learned for years of experience. And now I'd like to yield 2 minutes to the gentleman from Minnesota, Mr. Allenson.
The gentleman from Minnesota is recognized for 2 minutes.
Mr. Speaker, let me thank Chairman Scott, Chairman Conyers, and also let me thank my colleagues on the other side of the aisle who see the wisdom of moving forward based on what we know about the disparity in crack cocaine sentencing now, what we've learned over the years. thank all of them for yielding to evidence, which I think is so important. You know, before I ever came to Congress, Mr. Speaker, I spent the better part of my life representing people in the courts of our country as a public defender, and representing in the courts of our country in federal and state court. And I saw so many of these cases. And the thing that disturbed me the most is the human potential that would just be thrown away, as I would have to tell a young person who was caught with crack that if they'd had cocaine, they would have a chance at probation. They would be able to really take advantage of some treatment and perhaps reconstruct their lives. But because they had crack, their lives were going to be basically over at a pretty young age, thrown away in a cell to have really no real opportunity, being in prison for 5 years for what another person would get probation for. And this made it incredibly difficult to argue that our system of law was fair, that we believed in justice, that we thought it was right and just to treat people the same for doing the same thing. The fact is, the chemical difference between crack and cocaine is the difference between water and ice. It's the same thing. And you cannot explain to people that for doing the same thing that they should get 100 to 1 more severe treatment. It doesn't make sense. So let me commend people on both sides of the aisle for correcting this severely disproportionate and unfair anomaly in our law. And I take no blame for anybody, but I will say that there are thousands of people, literally thousands of people, who may get a real chance at life because of a mistaken drug case.
Time has expired.
Because of this law. Thank you. I yield back.
Time has expired. First gentleman from Texas, rise.
Mr. Speaker, may I ask how much time remains on each side?
Certainly. There are 9 minutes remaining on both sides.
Okay. Mr. Speaker, I'll yield 2 minutes to my friend and colleague from Texas, Mr. Paul.
Gentleman from Texas is recognized for 2 minutes.
I thank the gentleman for yielding. I ask unanimous consent to revise and extend my remarks.
Without objection.
Mr. Speaker, I rise in support of this legislation. It's called the Fair Sentencing Act. I'd like to rename it, though. I'd like to call it the Slightly Fairer Resentencing Act, because it really makes an attempt to correct a very, very serious problem in equal justice in our systems, and that effort, I think, we should all applaud. But I would have much preferred H.R. 3245. I was original co-sponsor of that, along with Congressman Scott. But I think this is a typical example of trying to fix a problem that we invite upon ourselves. In economics, I adhere to the position that once you want to do good in the economy, and with all the best motivations, we do things and we create new problems, then we have to go back. And if you get 2 new problems for every intervention, then you're constantly writing laws. Well, in social policy, I believe the same thing. It was trying to improve social policy with crack cocaine. There was no malevolence on this. It was designed to help people, especially the minorities that were using crack cocaine over powder cocaine, and they thought this was terrible. And it turned out that it backfired. It actually hurt minorities and didn't help them. And here we're trying to correct this disparity. And it just, to me, confirms the fact that the government management, whether it's the economy or social policy, doesn't make a whole lot of sense. When this country decided it was very dangerous to drink alcohol and we had to stop it, back in those days, in the teens of the last century, they decided in order for the government to do this, they had to amend the Constitution. Can you imagine anybody being concerned today about what we do here and say we have to amend the Constitution? Oh no, we amended it. It was a bomb. It made alcohol much more dangerous. All the drug dealers sold the alcohol, and the alcohol was more concentrated and it was less pure, and people died. People woke up and they repealed it. This is what is going to have to happen someday. We need to repeal the war on drugs.
Gentleman's time has expired. Gentleman from Virginia.
Mr. Speaker, I reserve the balance of my time.
Gentleman reserves. Gentleman from Texas.
Mr. Speaker, I have no other speakers at this point on this side, and I'm prepared to close at the appropriate time.
Gentleman reserves. Gentleman from Virginia. Gentleman from Virginia.
Mr. Speaker, I have an additional speaker on the way, and he'll be here presently. Huh? Say again? Is he coming? Okay. Mr. Speaker, I yield 1 minute to the Majority Leader of the House of Representatives, the gentleman from Maryland, the late Mr. Hoyer.
The late Mr. Hoyer is recognized for 1 minute.
The reports of my lateness are overstated, but I'm certainly glad that I got here in a timely fashion. And because I did, I rise in support of this legislation and thank Mr. Scott for yielding to me. I also want to thank the former Attorney General from California, Dan Lundgren, for working with me on this issue, and others, Jim Sensenbrenner and others. 2 decades ago, Congress responded to the addictiveness of crack cocaine, a terrible drug, and the violence it brought in its wake by establishing harsh mandatory sentences for possessing and dealing it. In supporting that policy, Congress also created a wide disparity, however, between crack cocaine and powder cocaine sentences, both addictive, both illegal. Possessing an amount of crack equal to the weight of 2 pennies has resulted in a mandatory minimum sentence of 5 years. In order to receive a similar sentence for possessing chemically similar powder cocaine, one would have to be carrying 100 times as much cocaine. It has long been clear that 100-to-1 disparities had a racial dimension as well, helping to fill our prisons with African Americans disproportionately put behind bars for longer. The 101 disparity is counterproductive and unjust. That's not just my opinion, but the opinion of a bipartisan U.S. Sentencing Commission, the Judicial Conference of the United States, the National District Attorneys Association, the National Association of Police Organizations, the Federal Law Enforcement Officers Association, the International Union of Police Associations, and dozens of former federal judges and prosecutors. They have seen firsthand the damaging effects of this unequal sentencing guidelines up close, and they understand the need to change them. That's what this is about. The Fair Sentencing Act does that. It also strengthens sentences for those who profit by addicting others to drugs, as it should do. This bill has overwhelming bipartisan support. Whatever their opinions on drug policies, members of law enforcement, community advocates, and members of Congress overwhelmingly support this bill. In fact, it passed the Senate unanimously. In the words of a letter signed by a bipartisan group of its sponsors on the Senate Judiciary, Senators Leahy, Sessions, Feinstein, Hatch, Specter, Grassley, Durbin, Graham, Cardin, Cornyn, and Coburn, a very, very bipartisan and broad spectrum group of supporters. They said this: Congress has debated the need to address the crack powder disparity for too long. We now have the ability to address this issue on a bipartisan basis. And they supported this legislation, which is, again, why it passed in a bipartisan fashion through the United States Senate. My colleagues, I urge support of this legislation. I am pleased that the leadership on both sides of the aisle will be supporting this legislation. We do so for the same reason that Senators Cornyn and Hatch and Graham and Sessions all support this legislation. It's the right thing to do. It will enhance, not diminish, prosecution, and it will lead to better justice in America, while at the same time making sure that we penalize and hold accountable those who would addict our children and our fellow citizens. And I urge support of this legislation and yield back the balance of my time.
The gentleman yields back. The gentleman from Texas.
Mr. Speaker, I'm prepared to close if the gentleman from Virginia is prepared to close. And if
I'm
he's
prepared
the
to
last
close,
speaker.
Mr. Speaker.
Gentleman from Texas.
Mr. Speaker, more than any other drug, the majority of crack defendants have prior criminal convictions. Despite claims by some, this is not an issue of one-time crack users being prosecuted for possession. This is about offenders who perpetually peddled this dangerous drug and should pay the price for their actions. Despite the devastating impact crack cocaine has had on American communities, this bill reduces the penalties for crack cocaine. Why would we want to do that? We should not ignore the severity of crack addiction or ignore the differences between crack and powder cocaine trafficking. We should worry more about the victims than about the criminals. Why would we want to reduce the penalties for crack cocaine trafficking and invite a return to a time when cocaine ravaged our communities, especially minority communities? This bill sends the wrong message to drug dealers and those who traffic in destroying Americans' lives. It sends the message that Congress takes drug crimes less seriously than they did. The bill before us threatens to return America to the days when crack cocaine corroded the minds and bodies of our children, decimated a generation, and destroyed communities. Mr. Speaker, I hope sincerely that those who support this legislation are prepared to take responsibility if cocaine trafficking increases, if our neighborhoods and communities once again become riddled with violence, and the lives of Americans are unnecessarily destroyed. I hope that doesn't happen, but at least today we have gone on record as saying that there was a warning, and I can only hope that at some point in the future it will be heeded and responded to. Thank you, Mr. Speaker. I'll yield back the rounds.
Gentleman yields back. Gentleman from Virginia.
Thank you, Mr. Speaker. Mr. Speaker, this bill does not reduce the disparity from 100 to 1 to 1 to 1. It does not eliminate the mandatory minimums, but it is a step in the right direction, and therefore I urge my colleagues to support S. 1789, and I yield back the balance of my time.
Gentleman yields back. All time has expired. The question is, will the House suspend the rules and pass Senate 1789? Those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, 2/3 being in the affirmative, the rules are suspended and the bill is passed, and without objection, the motion to reconsider is laid upon the table.